Hi, everyone. Thanks for joining us today for this webinar on bringing international practice back home, Churchill Fellowships on trauma-informed and child-centred legal services. My name's Alma Mistry. I'm the Acting Executive Director of National Legal Aid. I'm currently battling a cold, so just excuse me while I do my opening. I may have to grab a glass of water. I'll begin, of course, by acknowledging that I'm on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to elders past and present. I'd like to extend my respect to any First Nations people joining us today. Sovereignty was never ceded, always was and always will be Aboriginal land. And across the country at the moment, we're facing very punitive criminal justice changes that as people working in the legal assistance sector we know will increase disadvantage and harm to First Nations communities. I want to acknowledge the strength and ongoing leadership of Aboriginal community-controlled organisations. And as we meet today to discuss more holistic approaches to legal work, recognise that First Nations communities and organisations have consistently modelled these approaches in many settings. So thank you for joining us. Some short housekeeping. We are recording this webinar and it will go on the National Legal Aid YouTube channel and be sent out to everyone who attended and registered. Please feel free to share it with others interested in this work. For those who don't know about us, National Legal Aid represents the 8 independent legal aid commissions in each state and territory. Legal aid commissions work collaboratively to deliver legal services and non-legal advocacy and support, aiming to ensure that people who most need it can access the justice system and achieve fair and equitable outcomes. NLA also works with the legal aid commissions and others in the legal assistance sector to share their practice experience and advocate for fairer laws and systems. A critical part of our work is continuous improvement and ensuring that our services meet people's needs. We had a huge amount of interest in this webinar, over 380 people registered, and I think that reflects the long-term and growing interest in the topics our speakers are going to talk about today. Widening inequality since the COVID-19 lockdowns and constellating clients' needs are factors many of you will be seeing in your work every day. Being trauma-informed, promoting participation and taking a rights-based approach are all crucial ways of working for lawyers assisting and representing people experiencing marginalisation. There are many examples across the legal assistance sector of embedding these approaches in meaningful ways that improve our clients' agency and justice outcomes. But at the same time, I'm sure we've all seen and heard instances where sometimes these phrases can be used in an empty way or without the context and systemic change that is needed to enable these more holistic practices. Both Chen and Elicia's projects examine the individual and systemic practices that must occur to shape better services for legal assistance clients, including children. So today's a chance to step back from our day-to-day work, to reflect on what we already do well as services and think about the ways we can build upon that by learning from innovative approaches overseas. That brings us to our speakers and their deep dives through their Churchill Fellowships. A Churchill Fellowship is an opportunity for Australians and permanent residents to travel overseas to learn more about an issue they're passionate about and to implement their findings upon returning home. Today, you're going to hear from 2 Churchill Fellows, Chen from Legal Aid New South Wales and Elicia Savvas from Victoria Legal Aid. A Churchill Fellowship is also about building networks of like-minded professionals across multiple jurisdictions and sharing Australian best practice. Many of Chen and Elicia's recommendations regarding systemic change require collaboration across the sector and different sectors and change at multiple levels. So thank you for making the time to be here today. Following the presentations, we're going to have an opportunity for questions and answers, so please submit questions anytime during the webinar using the Q&A function. Now to our first speaker, Jennifer Chen. Jen manages the With You training project on behalf of National Legal Aid. With You has designed training in partnership with people receiving and delivering legal aid services. It was informed by listening to over 500 stories around Australia, including from 195 lawyers, 98 people with lived experience of trauma, 23 carer, family, supporters and kin. By May, training will have been delivered in person in every state and territory. Chen is a 2023 Churchill Fellow and will be speaking about her project to investigate trauma-informed legal services for people experiencing marginalisation. Thanks, Chen.
Thanks, Alma. So as Alma mentioned, my name is Chen, and a Churchill Fellowship has been such a privilege. It's been something I've been working towards for a number of years. I'm passionate about lawyers being trauma-informed after practicing as a mental health lawyer myself, studying psychology, and also supporting a loved one with complex mental health through various legal proceedings. So through my current leadership of the National Legal Aid with You project, training lawyers on how to be trauma informed and rights based, I've seen how it goes without saying that most, if not all, of the clients who come to legal aid or community legal centres have experienced some kind of trauma, or contact with the justice system is re-traumatizing. Can be re-traumatizing. And while law schools may train us to give accurate legal advice, it doesn't quite equip us to be safe and effective with a person sitting in front of us who might have experienced a lifetime and multiple layers of oppression, and or are juggling multiple complex needs. And as a profession, I'd have to say, lawyers, we have power. We're at that interface between this person in front of us and a legal system which may be opaque, potentially harmful. And so I think there's real potential for us to have a huge impact in the way that we practice. I think that being trauma informed is sophisticated on one hand, but it's also simple in other ways. And I love the way that this quote by Dr. Rubik, the Commissioner for Victims of Crime in Canada, poses the simple question that we can always ask ourselves. So, where did my fellowship take me? I visited all the cities marked on this map with yellow planes. So I went to Bangkok, Mesa in Thailand, Manila in the Philippines. I presented at the International Congress on Law and Mental Health in Barcelona, London and Edinburgh and Glasgow in the UK, and Toronto and Vancouver in Canada. I also conducted interviews online before, during, and some after my travels, and they're marked by the green pins on the map. And who did I speak to? So in the end, I spoke to over 100 people in 76 interviews. To be honest, I probably wouldn't recommend that many, but I had the privilege of speaking to solicitors and barristers from a wide breadth of practice areas: personal injury, family, criminal defence, prosecution. I spoke to lawyers who worked at legal aid, private practitioners, community legal centres. I spoke to people with lived experience of trauma and the legal system who'd become advocates or trainers. I spoke to many trauma-informed leaders, including people who are policymakers and regulators, mental health professional, judicial training academies, and academics. So I'm really conscious that everybody in this room right now is probably managing a very busy workload. And so I distilled my research findings into practical recommendations for these three categories of professionals: lawyers who are practicing, leaders of legal services, and also people in positions to make big picture change, such as policymakers, law schools, regulators, and law societies. That's how I've structured my presentation today, and how the executive summary that will be circulated is also structured. So what does a trauma-informed lawyer do? I loved this quote by a Canadian youth justice lawyer who said, "We don't expect our clients to trust us. Trust must be earned, but we are prepared to do the work to be trustworthy." So I'll start with this story from a criminal lawyer from Just for Kids Law in the UK about a boy who's 16 years old. Let's call him Jake. So a civil order had been made preventing Jake from living in his hometown, which was devastating because it cut him off from the few helpful family connections he had. And this lawyer started by asking, what has happened to Jake? She sought his consent to access records, so he didn't have to retell his story yet another time. And she took a trauma-informed approach by considering his story as a whole, looking at his early childhood and drawing a thread of the multiple long-term impacts of trauma throughout his life. So, for example, she was able to reframe behavioral challenges stated in various state care records as being a reflection of the disruptions caused by frequent transfers to different care facilities across the country. She showed how being prevented from connecting with his family led him to rely on known criminal groups as a support network instead. She showed how frequent, intense, and traumatizing encounters with police furthered his reliance on this criminal group, and also the intersectionality there with traumatic experiences of racism. And she also found that actually a number of convictions in the past were attributable to a lack of previous legal representation because certain defenses available to him hadn't been explained to him properly. And her trauma-informed case theory also identified offending itself as a form of trauma. She was able to show how he'd been groomed from a young age into criminal activity, and how his travel across the country to transport drugs at a really young age was actually very exploitative of someone experiencing vulnerability. And in written and verbal submissions, she provided this broader context for his behavior, not to excuse it, but to show the impact of system failures rather than as his behavior only being framed through a narrow criminal focus. So, for example, over a 2-year period, Jake had had over 20 placements in various care institutions, and he'd always asked to go to school, but the failure to give him consistent placement meant he couldn't, and he couldn't be kept safe either. In verbal submissions, so in front of Jake, she drew attention to his strengths, like his intelligence, his humor, his sensitivity, the plans he had had for his life. And the civil order was opposed successfully. Outside of her written and verbal submissions, she was also an advocate for him by using informal opportunities to talk to police, social workers, youth workers in court to build their capacity about their understanding of trauma. So I often hear people say that, sorry, before I go on, I might just also say that in the US, there are mitigation specialists who work with clients on death row who have this function of doing a deep dive on clients, where if they come from, interviewing childhood connections and telling this fulsome story so this person isn't just framed in a deficit-based model before the court. It's not just this one incident of offending that defines their whole life. And even though we don't have an analogous role here in the Australian legal system, you can see from this example that I've just given that we can all play that role in telling our client stories in an empowering, fulsome way, strength-based way. So the Advocates Gateway is a website that provides practical guidance for communicating with vulnerable witnesses and defendants. So I raised this here because I often hear people say, the adversarial nature of the legal system itself is inherently traumatizing. And I often hear this argument being sometimes used as an attempt to resist any sort of changes to the current way of doing things. But the Advocates Gateway, for example, has a number of guides widely endorsed by senior judges and professional bodies in England, Wales, Ireland, and Scotland. And there are guides for how to work with someone with certain forms of disability, for example, how to ask questions with young people based on their level of cognitive development to engage them meaningfully and provide access to justice, and not engaging in the toxic theatrics that we can often become familiar with. And so I use this as an example to show that even in practices such as cross-examination, a shift towards trauma-informed approaches is possible. So what does a trauma-informed lawyer do? The hard work, of course, is translating what I'm about to say into your specific practice area. What does it mean for you as a family lawyer, given the way the legislation is written? What does it mean for you in your practice if you give a lot of your advice over the phone or online? But overall, trauma-informed lawyers can recognize the impact of trauma on their clients, not just single incidents. So, for example, there was a time when Jake was found living in a shed by police, but it's also the impact of systemized, routine, a lifelong of oppression or multiple layers of disadvantage. A trauma-informed lawyer can apply the principles of trauma-informed practice in all aspects of their work. So there's more written online now around trauma-informed communication with clients. How can you communicate to somebody that you're a safe person, that you believe them, that you aren't going to be judgmental or unsafe like other parts of the legal system they've already worked with so far? So, for example, the youth crime lawyer was able to validate how challenging repeated court appearances were for Jake when he was used to speaking to unsafe adults. A trauma-informed lawyer can also, as I mentioned earlier, think about the impacts of trauma in the way that in developing case theory. What are your clients' strengths? How can you bring that out in both your written and verbal advocacy? Are there times where it's unnecessary or more harmful to rehash specific graphic details of your client's trauma in an open court? And is that going to lead to the sort of outcome that's meaningful to them? It's also about being trauma-informed in case management. How can you support your client through all the steps of the legal process in a way that's working with them, drawing on their expertise, presenting options, and allowing them to choose what's meaningful to them? And trauma-informed lawyers can also recognize and respond to the impact of trauma on themselves. So it goes without saying that vicarious trauma is a natural response. It's a normal response to repeated exposure to trauma, which is inherent in a lot of our work if you're working with people with trauma histories. But I also want to say it's not an inevitable endpoint for lawyers working on social justice type of matters. I think that it's fantastic that the legal profession is talking about vicarious trauma more now, but I also think that sometimes in our rush to raise awareness about vicarious trauma, we make it sound like it's an inevitable endpoint for all of us. It's sort of the last stop of this train that we're all sitting on. But instead, I would suggest that trauma-informed lawyers know how to self-reflect. And this is a process of considering how your work is impacting you over time in both your workplace and also in your personal life, and also how then you might be impacting your client and future clients over time. This can be hard to pick up because the impacts of vicarious trauma might be subtle. It might just show up as irritability or less engagement, for example. But a great space to do this is through trauma-informed supervision, which is not just supervision over the accuracy of your legal advice, but it's that space for you to think about, for you to chat to somebody about, did I get the outcome that I wanted, that the client wanted? How does this client remind me of my own life experiences? And what did this experience do to me, for example? In the UK, there's an institute that's specifically training people to be family law supervisors, the FLIP faculty. And I think that this practice over time allows us to have a sustainable professional identity. How can we stay in this work that we find meaningful, that aligns with our values for the long run? So next, I'll be talking about what do trauma-informed leaders do? So I met Deepa Matto, the CEO of the Barbara Schleifer Commemorative Clinic in Canada. This is a community legal centre that serves women of colour or people who identify as women from marginalised communities who've survived violence. So Deepa was generous, humble, relaxed, funny. She had such a busy day, but she gave me 2 hours of her time. And she, you know, but she was still so human and approachable. So she didn't express this need to fix or do everything straight away. She acknowledged the very real operational challenges of her role, including, short-term funding or funding uncertainty, really complex and growing client demand, policies and laws that impacted her client groups negatively, and really complex operational decisions. But it was really clear to me that she'd invested in deep personal growth, and that she brought her community legal centre on a transformative process over many years, and she'd somehow built this culture of safety in her staff. She gave me an impromptu tour of her office after our official interview ended, and I could see from the way that her staff interacted with her, interacted with each other, that people felt really safe and supported to be themselves at work. And this is really, the seemingly simple environment is really challenging to achieve. If leaders are working in systems that are infused with trauma, how can we create cultures and systems in response that are safe, that are trauma informed? Well, part of what she did was give her staff permission to slow down. So she would often say that, especially in times of really high demand. When people can often feel like I'm behind, there's always another call that I've got to make. She was able to reframe that thinking as to say, look, we are doing our best within our scope. She was able to nurture constant reflection, not only within herself, but in her leadership team. What did I learn from you today? How could she take advice from people from different backgrounds? How could she express how much she valued people? She embedded trauma-informed practice into her policies, operational policies, as well as high-level strategic policies, and she'd redesigned intake. So she redesigned service design so that clients received efficient trauma-informed services from beginning to end. And she also engages in that high-level systems change work. I noticed that in all of the jurisdictions I went to, people not only focus on trauma that individuals had experienced, but also that broader oppressive or systems factors that led to that trauma. So services might be trauma-informed and anti-violence, trauma-informed and anti-oppression, trauma-informed and feminist, trauma-informed and rights-based, but that balance is always really important. And Deepa did a lot of work in trauma-informed feminist policy and legal reform, building capacity for other organizations and law schools. The other example I wanted to give of trauma-informed leadership was by the Honourable Rachel Tangway when she was at the Rockland Family Treatment Court. So this court was established in 2001 to support parents with substance use in their recovery and reunification with their children. And she led this court over a number of years from being parent-focused, punitive and compliant-based to being trauma-informed and family-centred. And she also started with relationships within her own team, because she noticed that prolonged exposure to vicarious trauma over time has started to impact the way that people related to each other and team dynamics. And it took a lot of hard work. She attended all the staff meetings to have honest conversations about workplace culture and how they could shift to a more supportive, respectful, collaborative way of interacting with each other before becoming safe for their clients and the people who come through the court. And then she reoriented the way that the court operated, so it was much more client-centered by voluntary enrollment, by taking a problem-solving approach to treatment rather than punitive approaches when people didn't comply. She welcomed open communication from people to say what they were really struggling with, what triggered them and stopped them, sort of hindered them in their roads to recovery. She sat at the same table as clients and families to try to balance that inherent hierarchy and power imbalance in a lot of courtroom environments. Critically, she also had a lived experience workforce, which means people who had used substances and who had gone through a similar legal process in the past to work with clients to help really unpack what the process was about, and also to give their advice from the client perspective about how seemingly simple processes could be redesigned. And as an outcome, the court rarely uses punitive sanctions today, has a really incredible reputation, and has now shared its lessons learned with other specialized drug courts. So in terms of trauma-informed leadership, I want to acknowledge that, this quote demonstrates my point earlier. From this quote from Dr. Janet Mosher, a Canadian academic, again, really encourages leaders, I think, to consider the broader forces behind trauma for entire communities. Not all practitioners are interested in systems change work in terms of writing policy or law reform submissions, etc., and that's fine, each to their own. But as a leader, it's really important for to have avenues in your organization to harness that really invaluable frontline experience of working with clients and seeing how laws and policies impact them, and to feed that up into broader advocacy campaigns with government, with different government departments, the community, etc. So we're not just so that in addition to doing great work for individual clients, we're also addressing the broken rules of the system, so to speak. So I want to acknowledge here that it is so challenging to be a trauma-informed leader. It might be lonely, making those tough decisions. The stakes may be really high in terms of the potential impact on clients experiencing vulnerability and staff well-being. Rates of burnout and vicarious trauma in the legal assistance sector are well documented and on the minds of, I'm sure, every leader who's in this webinar now. You may feel like you're putting out multiple fires on a day-to-day basis, balancing funding challenges, operational demands, the high volume and complexity of client demand. Maybe your team has unrealistic expectations of what you are or aren't able to achieve. So it's really challenging, and I want to acknowledge that. And I want to acknowledge there's no single correct formulaic way to be. If only there was a checklist, if only there was a flowchart I could just flash on the screen now. And all the leaders that I met who had overseen transformative change over a number of years used many combinations of all of the sort of ideas that I've got on the screen now. You know, some started with that organizational readiness assessment, thinking about what is currently working well in our service, where do we want to be? Sometimes they formed a steering committee or a team to ensure that this priority didn't fall off the agenda. Sometimes it was really high level change. They put it in their strategic plan. Sometimes it was really bottoms up, focusing on staff well-being, identifying champions within the organization, introducing lived experience workforce, which must always be done carefully, is absolutely key, and in many ways a fast track to transformation, because you're not just thinking about what you think clients might want, you're hearing directly from the people impacted by your services, going through the system about what's most important to them. But before any of these actions have to happen, I have to say the starting point is always that self-reflective piece, self-awareness. Are you currently in a good place yourself? Are you currently able to self-regulate, able to be grounded, well supported, and have healthy connections outside of work to so that you are the safe foundation, the safe space for your staff and ultimately for your clients? So the final section of what I'll be talking about today is practical recommendations for the sector as a whole. So that includes policymakers, law schools, regulators, and law societies. So what does a trauma-informed legal system, what might it look like? Well, I found that Scotland was best practice. I was so impressed. So in Scotland at the moment, there's a bill, the witnesses, victims and justice actors bill, I think it is, with really broad trauma-informed reform for the sector that includes significant changes in practice for courts and police. There's been so much change in relation to victims and witnesses through court proceedings. There's a trauma-informed lawyer certification course run regularly through the Law Society of Scotland. There are multiple interagency meetings between police, lawyers, the courts, talking about how we can be trauma-informed, not just why should we be trauma-informed. And I thought a lot about how this is possible, how they've reached this point. And I think that it was, again, multifaceted. There was top-down, bottoms-up change, and all that was in between. And so I think that's a really encouraging message for us, actually, because it means that no matter where you are in the system, no matter what your sphere of influence is, we all need to work together, and we can all make changes where we are to contribute to ultimately having a shared agenda, having a shared understanding of what being trauma-informed looks like in practice, so that we can work towards that together. So in Scotland, for example, there's really high level commitment from the judiciary, and really senior judges led task forces and inquiries about changes to practice, especially in relation to witnesses and victims. There was a lot of lived experience partnerships. So a victims task force was again built on victims' experiences of the justice system. So those really changes that are meaningful to people who are experiencing the system. And from that, they developed a knowledge and skills framework to grow the capacity of the entire workforce in the justice system, carefully graded or tailored, I should say, depending on your specific role. So for example, if you work in a corporate type function, it's really important to be trauma informed. But if you're working directly with people with trauma histories, you need to be trauma responsive. And the trauma-informed certification course through the Law Society is open to people from all different practice areas. Scotland's legal aid puts almost all their lawyers through it. And part of that was also from the demand generated by law students and law schools for this kind of approach as early as possible. International Justice Mission is a not-for-profit that does anti-slavery work. I thought they were a great example of working on multiple levels to encourage more trauma-informed responses. In the Philippines, a big focus for them was online child sexual exploitation, and they worked at multiple levels. So again, they really prioritize survivor voices, helping to set up the Philippines Survivor Network. And these survivors now tell their stories as part of advocacy and training to government agencies, to judges. So they spoke at National Congress directly to judges about how, for example, when they're rescued from situations of slavery, it's really important for them to go home as soon as possible so that they can be with their families, so that they can work. And that's more important to them than being sort of delayed in shelters in a third country, for example, as criminal prosecutions take place. The IJM, the International Justice Mission, also trains prosecutors on the importance of actually meeting victims before court processes, and police, because it's really complex, as you can imagine, to investigate this emerging crime. They also build trauma-informed networks of care. So there's where they pull in social welfare services, department agencies, psychologists from universities, etc., sort of in a resource-scarce environment to support victim survivors and their families. And they also strategically partner with local government, in addition to having those higher seat at the table in the higher levels of government, because local governments have oversight of local issues in the communities, and they understand where multidisciplinary responses already exist. So again, working at many levels. So I've spoken about a shared agenda, workforce development. It goes without saying that a trauma-informed judiciary is really important as well, and monitoring and evaluation in terms of being able to demonstrate and articulate the impacts of trauma-informed lawyering. I also want to mention here how important it is to build trauma-informed lawyering into funding agreements. And that means having specific trauma-informed practices and dedicated roles so that this practice doesn't fall off the agenda, so that leaders don't have to choose between direct service delivery, for example, and providing supervision to their staff, and that we can have dedicated roles to make sure that, especially with the strong operational pressure that a lot of our services face, that we can continue focusing on the long-term transformative change that's needed. So something that really surprised me that I wanted to share during my research is just that Australia is actually doing well in the space. We're arguably set up for success. I think it's easy to take for granted sometimes that we do live in a liberal democracy, that we can campaign and advocate for community concerns. And even though, we can argue whether or not it's effective, but there are avenues for us to hold the government to account for the impact of laws and policies on clients experiencing marginalisation. That didn't exist in all the jurisdictions that I went to. And I think we actually have a strong, we do have existing infrastructure for collaborations, including through national legal aid. And we can build upon that and really harness that to disseminate existing good practice. I found when I was meeting with services overseas, people were really surprised and wanted to know more about a lot of great work happening in Australia, especially in relation to integrated service delivery, service models where lawyers are working in partnership either with in-house social workers, mental health workers, etc., or having partnerships in the community. There are pockets of great practice in Victoria, for example, in relation to lived experience workforces. And there's great decolonisation work happening in Australia as well. So I think we are in so many ways set up for success, and we can build upon what we're already doing. I'm really conscious that I've shared so many ideas. And there's so much change that has to happen. I spoke to Dr. Ben Purin, a Canadian legal professor who used to be a legal advisor to the a conservative Canadian Prime Minister. And he was transformed through research, hearing from people's lived experience of the criminal justice system. And now he advocates for a really wide range of abolitionist and sort of transformative approaches. And I said to him, I said, Ben, you have so many ideas in your book, Indictment. What do you think? Like, where should we start? Where's the low-hanging fruit? Where are we going to get the most impact? And he said, well, actually, there are two tracks of systems change. And this is an idea that is also strongly advocated for by the First Nations Council in Canada, in British Columbia. And it's this idea that if you work in government, for example, you might be able to effect change to sand down the sharper edges of a challenging legal system, for example. Or if you're in other spaces, you might be able to advocate for completely abolitionist, sort of taking down existing structures and building, reimagining trauma-informed structures. But wherever you are, there is so much change that's needed that you can just start by identifying what your sphere of influence is and start there. And systems change is cumulative, which means, in my view, that it doesn't matter where you begin. As long as you do begin, the impacts of what you do can have a cumulative impact if we're all starting to do whatever we can to ensure that our services and our individual practice is more trauma informed. So on that note, I want to say thank you so much for attending. I'd love to hear from you and to find out ways that we can collaborate. So please do be in touch. Thank you.
Thanks so much, Jen. That was fantastic. It seemed like you travelled the whole globe in your Churchill, so it was great to hear about those examples. I'm going to now introduce our second speaker, Elicia Savvas. Elicia is the Associate Director of Child Protection Services at Victoria Legal Aid. She has responsibility for the design and delivery of legal assistance to children and families in the child protection system across Victoria. Elicia also helped set up VLA's non-legal early intervention service, Independent Family Advocacy and Support, or IFAS. IFAS prioritises First Nations parents, parents living with an intellectual disability, and culturally marginalised parents to navigate the child protection system and avoid court proceedings where possible. Elicia is going to take us through her Churchill on investigating child-centred legal services in child welfare law. Thanks, Elicia.
Thanks, Salma. So I'll just start with a couple of acknowledgements. Firstly, that I am on the Wurundjeri country and pay my respects to elders past and present. I also just want to thank the Churchill Trust because it was an amazing experience to be able to undertake a Churchill Fellowship and learn from so many people overseas, and to Victoria Legal Aid and National Legal Aid for letting Jen and myself share our findings today. So Jen and I didn't coordinate our projects. We met at the first meeting of Churchill recipients, and we saw that there was a lot of synergy between our projects. So it's been great to be able to collaborate after we've finished our travels as well. So just in terms of my background, I guess just to say that I have had a really long-standing interest in how we do our jobs as lawyers. And so I've really thought about this a lot in terms of how we work across child protection and family violence as well, and thinking about whether justice responses to social issues that children and young people are facing are appropriate and whether they are meeting their needs. So I guess that's just a little bit of context for my project. Can we just jump to the next slide again? Thanks. And so I know there's probably people in the audience today who might be interested in applying for a Churchill Fellowship. So I just thought I'd take you through my project and sort of how I came to set up the project. Because I think that's one of the really critical things, is having a clear project and a rationale for why your project is important and and how it can contribute. So for me, I was thinking about children's participation and how legal services address children and young people's holistic legal needs in child protection. And so I've been working for about 15 years in the child protection legal system. And although children's right to participate is stated in law, I was thinking a lot about, well, what does this actually mean? And in the 15 years that I've been working as a lawyer, we'd really seen fairly minimal changes in how lawyers and courts are actually engaging with children. And this is sort of despite in the last couple of years, there's been a real growth in sort of public discourse around children's participation and children's voice, but we're not really seeing how that was coming through in legal services. So it really prompted me to think about, well, what does children's participation mean for lawyers who are providing legal services, which on the face of it are directed by children's instructions, which is the case in Victoria, with mainly client-directed legal representation. The other sort of context to this was the introduction of the child safe standards in Victoria. So the child safe standards require children and young people or organisations to ensure that children and young people are able to participate in decisions that are affecting them within the organisation. So thinking about how children and young people have a say in services that lawyers and legal services provide to them. The other reflection was that we also don't know how children and young people experience our legal services because we don't have ways of asking them. So overall, I was really looking at how we think about participation, children and young people's participation in both an individual and at an organisational level. And I guess why this is important, I think it's probably very familiar for anyone who's in the legal assistance sector that we know that for children and young people who are in the child protection system, the pathway into the youth justice system is really significant. So, just some statistics, 38% of children with in the child protection system have criminal involvement, and just increases as children enter into out-of-home care as well. And some research that was conducted by Victoria Legal Aid a few years ago found that children in the child protection system go on to be the highest users of legal services over their lifetime as well. So it suggested that there's a real opportunity for us when we're working with children and young people in the child protection system to address those needs and to try and stop their re-entry into or their entry into the youth justice system, and also re-entry into the child protection system as an adult. So on the slide now, that just tells you, sorry, just go back a slide, that actually just tells you the formal project that I proposed for the Churchill Fellowship. So just really thinking about how children's services are looking at holistic needs and children's participation. And just thinking about how we can sort of shift away from sort of more adult-centred sort of models of legal assistance into child-focused legal services. Okay, and so these are some of the sort of key research questions I set out to find out in my fellowship. Generally, there were no formal evaluations of different services that people that I saw for the organisations I met with overseas. So my approach to learning from this is really sort of a qualitative approach of really observing the services and interviewing staff as well to hear their reflections. Okay, so this is just a snapshot of the places I went to. I didn't quite go to as many places as Jen, but it certainly was enough. So in terms of the US, just to give some context, the issues that children and families in child welfare systems in the US are experiencing are really quite similar to the reasons why children are brought into the child protection systems in Australia. So even though our legal systems are quite different, there's a real overlap in terms of poverty-based issues, and there's really similar issues around for First Nations people in Australia with the disproportionality of people of colour and Black and culturally diverse communities being brought into the child welfare systems in the US as well. As people probably know, the US has quite a different approach. They're not signatories to the Convention on the Rights of the Child, but in the US, understandably, there's a very strong rights-based focus to legal services coming from the Constitution. So that was, that sort of rights-based focus was something that I was able to see in the services that I visited. In the US, most of the places I visited, well, the places are all working in a sort of best interest decision-making framework in terms of courts. But with the legal services I visited, there was a mix of best interest representation and client-directed legal representation. So that's quite similar, I think, to Australia, where we've kind of got that mix as well. And so the places I visited in California, New York, and Philadelphia, they all used interdisciplinary models of legal assistance. So that's what I was really looking at there. The second part of my travels were to Scotland and Northern Ireland. Again, quite similar issues experienced by people in the child welfare system, and again, a best interest decision-making framework, which is the overarching framework there. A key difference, though, is in the UK is that the Convention on the Rights of the Child is actually adopted into law. So that was really front and centre in the basis of children's rights there. There really was a very, very strong focus on children's rights at all levels there. So I'll tell you a little bit about the places I visited in the US to start with. So starting off in California, so I visited the Children's Law Center of California, which is, might be known to some people. It's a very, very large organization, a dedicated children's service providing assistance in child welfare. It's an institutional provider, and they actually provide assistance to every child from 0 to 21 in LA County who have contact with the child welfare system. So how that is structured from a sort of organizational point of view is that they have different firms within the organization to manage conflicts of interest, but it does mean that every child is able to be assisted by CLC without having to make referrals to other organizations in general. In terms of New York and Philadelphia, they do use more of a mixed model, which is similar to what we have in Australia with private providers as well, able to provide assistance where the institutional law firm can't provide that assistance. But there was a very, very high proportion of legal assistance provided in those organisations. So the jurisdictions for children and young people are 0 to 18, but children in most places could stay within the system until the age of 21. So the key features of these law firms that I visited were that every single child gets access to an independent lawyer, and they have that ability to stay in the system till the age of 21. So there were some slight variations in terms of the models of legal representation. So where there was a best interest model, say in California and Philadelphia, slight differences, and there were some quite sort of codified requirements in some places around requirements to meet with children directly. New York is a little bit different. So New York has the client-directed legal representation approach. So in terms of the best interest representation, there was generally a requirement for the lawyers to undertake their own investigation, which is separate from an investigation that would be taken by the Child Protection Agency. So that was quite a unique role. It's something we don't see at all in Australia. And in terms of what the legal teams looked like, these interdisciplinary teams were usually comprised of an attorney, a social work investigator, and at times they might have a peer advocate as well, depending on the different organisation. So particularly for younger children, it would be the social work investigator who would meet with children, particularly pre-verbal children as well. There was a really strong emphasis across the US in terms of outreach. So meeting with the child and going to where they're at rather than expecting children to come in to meet with the lawyer or the legal team. So that was quite a sort of child-centered focus there. And just on the slide, you see I've got a quote from an attorney at the Children's Law Center of California, who was just really reflecting, who had been an attorney working just directly with clients in another context, and then coming to work at CLC and working in a team with a social worker, just the value of seeing other disciplines and how they engage with children was a really positive reflection for them. So there were some benefits that attorneys reflected to me around having some of those investigatory powers, was that it helped them to identify better placements for children and think about things that were outside of what had been identified by family and community services as well. And so things that they saw were particularly real benefits coming out of their roles, that they were often able to find placements where sibling groups were able to stay together. There were particular different variations of the interdisciplinary models, but one particular model was where there was a consistent social worker who stayed with the child throughout their long, often very long running cases, given children were staying to 18 or 21, but having that consistent social worker available to meet with the child really helped build that trust for the child with the interdisciplinary legal team, but also for caregivers as well. And that they felt that resulted in them getting better information from the children as well. Okay, so in New York, so this is a photo of me and a judge and a training lawyer from the Center for Family Representation outside the Unified Family Court in New York. So what I've got here, I've got a quote from the Legal Aid Society, from the managing lawyer there, who was talking about the importance for them about client-directed legal representation, and really talking about the, that sort of unconscious bias that we may bring, and we have our own experiences. And so the importance of being able to have children directly being able to say what's important to them and expressing their wishes. In New York at the Legal Aid Society, so they have a juvenile rights practice, which was a really interesting service because they had they were able to provide legal assistance on a range of different legal issues for children who have those multiple legal problems, but they were able to do this in a way where they still had specialist services, so they didn't have lawyers trying to be across all different areas of law. So they had a child welfare team and a youth justice team, sort of sub-teams within their juvenile rights practice. So the benefits of that was it allowed cross-learning and a sort of upskilling across different areas of law, but it was one legal service, so it didn't require children to be referred to a different firm or a different sort of practice area. They could still work together. So it was a really good balance of being sort of child-centered and having the service delivered around the child themselves, but retaining that sort of specialist knowledge and specialist skill set within the practice. A very interesting program that they ran there is they have an education advocacy service, which could deal with specific issues around school exclusion and disengagement, which was a really a fairly prevalent issue in the child welfare system, perhaps more so than in Australia, but it was great to see that that was something that was coming out of that practice too. In California and Philadelphia, there were a number of other specialist programs, which on top of their generalist assistance for children and child welfare matters, they had specialist programs for particular needs. So some standout specialist programs were programs that were focused on young people transitioning from care. So usually sort of that older teen or the 18 to 21-year-old age group. And there was a use of peer advocates to support those young people in those programs. So the peer advocates were generally people with lived experience of care systems, and they were working alongside social workers and attorneys to really support that client engagement. And in Philadelphia, the peer advocates, so they just brought on new peer advocates at the time I visited, and those peer advocates, with their own lived experience, were helping to develop a youth board to help facilitate some care experienced young people to be able to have a say in terms of the direction of the organisation. California also had some other great programs, which I won't go into detail now, but if you want to have a look at my report, there's some really interesting programs around young people who are at risk of sexual exploitation, and a mental health advocacy team, which provided support to lawyers to understand and make sense of mental health issues that attorneys and social workers were dealing with for clients in their practice. Okay, so heading over to Scotland. So Scotland is an entirely different system again. I've got a photo here of the Children's Hearing Room at the Scotland Children's Reporter Administration. So that is where hearings about child welfare matters take place. So it itself looks very different from a courtroom. So the children's hearing system is a lay panel where they make decisions about children in both the sort of child welfare area and what we would call youth justice, but they would describe as children in conflict with the law. So they really had a different way of framing children who had particular needs and vulnerabilities in the system. There was still a role for courts in Scotland, so where the grounds of the child welfare intervention were disputed or where there was an emergency removal, courts still had that role, but the decision-making around children's best interests was in that hearing system. So what was a standout with Scotland was that Scotland have a really as a government and across all different agencies under that, there is a really thoughtful strategy called The Promise, which is really trying to bring everyone along to have a whole government approach to child welfare. So you can see on the slide, they have a couple of foundations, 5 foundations for their promise, their commitment to children and young people. And so the first is around children's voice. Children must be listened to. Family, children must be with their family where it's safe to be and to feel loved. In care, there's a focus on siblings and having a loving home. People, so thinking about workforce. Children are supported to build relationships with people in the workforce, and the workforce is supported to listen and be compassionate to them. And scaffolding, so children, families, and the workforce are supported by the system as a whole. So it was great to see this sort of shared vision taken up at different agencies across the system in Scotland. And that vision was developed with young people and families, as well as professionals who are working in the system as well. So I saw these foundations taken up by different agencies I've visited, and it was a really coordinated approach to thinking about children and young people. Probably the other standout about the Scottish Reporter Administration was their capture of data and reporting. It was publicly available, and that was, I think, a really important thing because it gives children and families and other users, people coming into the system, confidence that people are reflecting and looking at what they're doing, and it really gives an opportunity to improve and develop good practices as well. So that was a really critical point that I think would be great for Australia to take up. Just onto the next slide. The unique thing about Scotland, and in a different form in Northern Ireland as well, which I'll get to, was the role of independent advocates. So in Scotland, all children in the care system have the right to an independent advocate, and they might have access to a legal advocate as well if they can express a view, or so they might have both. but as a baseline, every child has an independent advocate. So the purpose of the independent advocate is really about children's participation and thinking about how the child would like to participate in decisions about their own life. So information is provided to children about the participation and about how to access that independent advocacy and how they can also access legal advocacy if they want that too. So the role of the advocate is to help the child present their views, and their job is to make sure that the child's views are heard. So it is entirely child-directed, and so the advocacy worker can only share information that the child wants shared. And they'll work with the child to work out how the child wants to participate in those hearings. So they might want to attend in person. They might not want to go. They might want to have an advocate relay information for them. They might want to join online. So the advocate is really helping them with that process. And that was really respected by the Scottish Reporter Administration and the panel hearings. So the role of the independent advocate, that's really distinct from the social worker at the local authority, which is the Child Protection Authority, because that social worker, their job is to make recommendations about the child's best interests, whereas the independent advocate is about helping the child have a direct say about what they want and what they think is in their own best interests. The independent advocate is different from the role of a lawyer, because lawyers are about using legal systems and seeking legal remedies. So you can see why you can have both of them together, but really have a different focus. So it's, in a sense, it's a role that's really dedicated to children's participation, not a sort of add-on to the role of a sort of best interest social worker or the role of a lawyer. So another organisation I met with in Scotland as well was a community legal centre called Clan Child Law. So they are a dedicated children's legal service. They get a mix of legal aid funding and philanthropic funding as well. So again, it's child-directed legal representation, and they're really focused on meeting the child where they're at and really building that trust in terms of their engagement with the child, and then going on to do some really great legal work. I guess one example of their approach to working with children was that they really prioritise that sort of building that trust and spending time. So one lawyer was saying that one of the children they were working with was just really into football. So they use football as a way of sort of building rapport with the child. And now for every appointment they have about the legal issue, they have to do 10 minutes of kicking the footy just to, get into that, just keep that relationship going and sort of before they can get into the legal work. And that worked really well for them. And I was just thinking about what Jen had said earlier about trauma-informed lawyering. Another lawyer from Clan Law had talked about having an advocate come with a young person, and it took 3 meetings of the advocate and the lawyer meeting to explain to the child what the role of the lawyer was, because the young person had this view that it was lawyers that had put their parents in jail. So they were, their sort of trauma experience of what had happened in early childhood with parents going to prison, they didn't have that trust. But having an advocate and a lawyer who was able to spend that time to build that relationship and build that trust was a really trauma-informed way of being able to establish that relationship with the client. So how the advocates and lawyers work together was that because every child has that independent advocate, advocates were able to identify if the young person had a legal problem and were able to make referrals to the child to have that, to get that legal assistance and representation at that point in time. So just over to Northern Ireland now. So a different model of independent advocacy here. So I met with the Children's Court Guardian Agency, which is an independent organisation with social workers who are independent safeguarders of children's best interests. So again, they assist every single child who's in social care, is what it's called there. So they have proceedings. They are independent from the social workers, essentially the child protection practitioners. They are a separate kind of social worker to them, and they are tasked with making independent assessment about what a child's best interests are and presenting that information to the court. So a judge who's making child welfare decisions is listening to both the social worker from Social Care Trust, the Child Protection Agency, and the guardian's independent assessment about the child's best interests. So in contrast to the US, where there might be an independent investigation done by a social worker in an interdisciplinary team, there was some really good efficiencies, I think, in Northern Ireland, where the guardian agency, so as the independent sort of safeguarder, they have full access to the trust's files. So they're using the same information that the social worker from the Social Care Trust have to form their recommendations. So where do lawyers fit in that situation? Well, if a young person was able to express views and wanted to, then that the guardian agency would arrange for a lawyer from a panel administered by the Law Society so they would engage a lawyer to work directly with that young person on a client-directed basis. So the independent social worker from the guardian agency would still proceed with making their best interest recommendations, but the child would be independently represented by a lawyer on their direct instructions as well. But if the child wasn't able to express views, then the lawyer would be engaged to represent the child's best interests. So some really interesting things about how the guardian agency performed their role. So they had a real focus on the development of professional standards for taking up their role. So those standards were co-designed with children and young people and also with staff. And so although guardians are still exercising professional judgment, they're primarily a social work background, they're still exercising professional judgment, but having these standards about expectations about how the guardians will perform their role, it sort of created some consistency about what children and young people could expect, and it was in line with what children and young people collectively had said was important to them. So that was great. They used child-friendly workbooks. That's what I've got a photo on the slide there, which was really tools to help engage a child in discussion about what they wanted and what was important to them. So these workbooks were co-designed with children again. And the other interesting feature about the Northern Ireland system was that once the decision was made in court, so the guardian agency would cease to be involved, but then there was a different organisation called VOIPEC, which is, again, providing independent advocacy for children at the point that they are in care. So they're supporting children to raise issues about if they've got concerns about their care and participate in sort of case planning decisions as well. So in that sense, that was a bit more akin to the Scottish model. So just thinking about independent advocacy, on the next slide, these are the real features about independent advocacy across all the different legal services and different systems I looked at. There was an opportunity for independent advocacy. So there was a guaranteed right for an independent advocate of some kind. It was either, whether it was a non-legal advocate or a legal advocate, that was a guaranteed right in all systems. There were opportunities for children to participate in different ways and in the way they wanted. So whether it was via an advocate, directly writing a letter, there was various ways that could happen. And the court processes were designed in ways that children could participate. and their voice didn't get lost in this sort of desire for expeditious decision making, which I think is a real driver that many of us would see working in the child protection system. In terms of relationships, having an advocate whose role was actually about being that trusted person for that young person, so they felt safe to express their views and their voice, that was critical. On reflection, it was that time was allowed for that relationship to develop overall, and that was really critically important. Having a dedicated role that was just around participation means that participation gets prioritised and it's not lost within all the different tasks that lawyers and various other people are doing. And also it meant that it was someone who was skilled in working with children. And so, again, in terms of independent advocacy, being heard, so allowing the child's voice to be heard directly was another key feature. There were the minimisation of unconscious bias and professionals' own experiences influencing decision making was really important. So that client-directed representation and thinking about ways to structure tools even within best interest decision making to be done in a way that allowed children to participate was important. And having equal rights for children to have their voices advocated in that decision making and not being diminished by the model of legal representation. So on the next slide, I've just got a snapshot. It's really small. You might want to have a look at my report on the Trust and on the Churchill Trust website. But this just shows the different tasks that that we have in Australia, particularly focused on Victoria, and the different tasks that we do as lawyers and how that is divided across different functions. So it shows how much actually is expected of lawyers in the child welfare system in Australia. And there's some real benefits to separating out some of those functions across independent advocate and social worker roles. So just in terms of my key findings, so the number one thing I found was that independent advocacy for every child in the child welfare system is critical. There was different ways of doing this. So the US model was about interdisciplinary practice with attorneys, social workers, and peer advocates. And the UK models were more about independent, non-legal advocacy with structured processes to bring lawyers in when it was needed. So both, while they're different, both models ensure that children that can participate and be involved in those systems to express their wishes. And the other thing I found with the non-legal advocacy, independent advocacy, was that it was a really effective way of coordinating support to children with multiple legal issues. So where children had criminal law issues and child welfare issues, an advocate can really help navigate that system for them. And I think critically thinking about children's input into organisational structures, the individual advocacy and really empowering children to have a voice in the decisions about their own care helps children to understand the power of their own voice. And that really did pave a way for children to have a say in sort of collective participation in service design, system design, law reform, and things like that. So it's a really good sort of precursor for actually having broader participation from children. I found that client-directed legal representation was the most consistent with Australia's human rights obligations. So that was great to be able to see that that really came through from most of the places I visited. But of course, there is a role for best interest legal representation where a child isn't able to express their wishes. And so that use of the sort of having the professional standards like in Northern Ireland was a really good way of mitigating those risks of unconscious bias in best interest representation. In terms of the legal services, promoting really high quality legal services, there were particular organisational policies which helped with that. So there were particular things like having dedicated training roles and quality assurance tools were really helpful, and having lived experience guiding some of those, some of that quality assurance as well. The use of specialist programs to assist the most vulnerable or most marginalised children and young people was really important. So I think those care leaver programs, especially that I saw them in the US and also in Scotland, were really great examples of children and young people with the highest sort of legal needs getting that extra assistance. But in terms of generalist legal assistance, the UK Children's Services, which were generalist services where children and young people could seek assistance for a range of things, they were really great at identifying emerging legal issues for children and young people. So really my recommendation for Australia is really around having this balance of specialised services and generalist services as well. And finally, there were a number of legislative and sort of system enablers that really helped children's participation and meeting children's holistic needs in child welfare. So, I think the Scottish model of having this shared vision about what it should look like for children and young people who are in child welfare systems was critical. In both the US and the UK, having clarity in the law around the role of the lawyer was really important. There were various approaches to courts in terms of minimising children's unnecessary contact with the court system, and reducing sort of crisis-based urgent proceedings, those kind of things, because those are often a barrier for children participating in court proceedings as well. And I think finally, one of the most important things in terms of a system and sort of laws was that the importance of independent judicial oversight for children when they're in care is needed, because that really it allows that independent review for children when they're in care, and we know that they are children and young people who are most at risk of other legal problems like criminal charges. So having that independent judicial oversight and a means for children in care to be able to access that judicial sort of oversight and review was important. And again, that was sort of links back to that independent advocacy function as well to liaise with that. So just a snapshot of my key recommendations. Children in child welfare need to have an independent, trusted person to assist them who's separate from the child protection system. It's someone who can focus on their needs and the needs of that individual child and is not tied up balancing the various needs of many children in the child protection system. Where a child is able to express their views, client-directed representation is the most consistent with human rights. So again, I've already covered off on the best interests representation, but having an advocate to be able to assist that where it's needed, and the use of practice standards and professional standards informed by children's rights and co-design with children is a really effective way of mitigating unconscious bias. And I've just set out here some of those system-based reforms which would really enable children's participation to be fully uptaken in our courts and administrative legal processes as well. So where to from here? So in Victoria at Legal Aid, we are trialling, we've commenced some project work to sort of give effect to some of these recommendations so far. So we are trialling giving children who have finished their court cases, if they're in care, offering ongoing engagement with a lawyer to check in and facilitate that ability to get assistance and navigate case planning and legal issues once they're in care, but there's no child protection proceedings. And we are undertaking a children's law project at the moment where we are working with children and young people with lived experience to develop feedback processes so we can start to better understand how children experience legal systems and make service improvements from there. And we are testing ideas of non-legal advocacy for children and young people as well. And we've had some really great conversations so far with Legal Aid New South Wales who are, thinking about these issues as well. And so I think there's real potential for us to think about this more broadly across Australia and across other legal aid commissions as well. And yeah, I think we're on to the last slide. So, Jen, do you want to join again? Thanks. Yeah, so we thought we've got a little bit of time to have a chat about just sort of tips and tricks about applying for Churchill Fellowships and thinking through that process. We know applications are open, I think, for maybe another 3 weeks. So if anyone is thinking about it, yeah, we've got a couple of thoughts about that. Jen, do you want to?
Yes, so I guess my biggest tip when developing your pitch is to speak in plain English, because in New South Wales anyway, the people who go the people on your interview panel are previous Churchill Fellows. So very talented, competent sort of leaders in their own right, but they might not know anything about your work. So be really careful not to use any jargon. My number one tip is to practice your pitch with friends and family who are in a completely different profession to you. And also when doing your pitch, I just sort of try to explain it like it's like doing a little 1 minute or 2 minute TEDx pitch. Be able to explain why your project's important, why now, why you, and why go overseas. So in terms of research, I'd suggest looking through the library of Churchill Fellowship reports to see what's been done already. But don't be worried about proposing a topic that's been done if you're doing a slightly different take, because often if you're doing often topics can be quite broad. Why you? So explain how, with your networks and contacts, with your subject matter expertise, you're the perfect person to go, and also can think about how you can explain what happens if they don't fund you. That's a good way of sort of putting a compelling case forward.
Yeah, I think, being really clear that you are someone who can implement the recommendations. So it's not just this is a great idea, like being sure and being able to say that, you are the person to be able to implement whatever comes out of your research.
How does it benefit the community? So this is a key selection criteria, but being able to articulate that with a degree of specificity, as well as being able to apply to a broad part of the Australian community, is key. Why go overseas for your project when you could just do online interviews, for example? I think for me, I really found that going to visit someone in their office and understanding all those intangible aspects of someone's practice, like the culture, the layout of the office, and also understanding how someone's service or work relates to the broader cultural dynamic is really important. So before we left, the Churchill Fellowship Trust said, make sure you're not just filling your days with back-to-back meetings, but you actually explore the city and you sort of understand how people, as much as you can in a short visit, sort of think and act in that particular place. And I sort of didn't really understand the significance of that until I got there. And then I understood, yes, how that's absolutely key, and how you can't really get that from online meetings.
Yeah, and I think for both of our projects, we were really looking at how people are interacting with people. So that is always better to be able to see that in reality, that, sort of relational work with people.
That's right. I have heard of other Churchill Fellows observing. So sort of like, I guess if you were to do a justice-related project, like observing court process, having consent to sort of sit in waiting rooms, and that's all really important as well.
Have we got questions? We've got time for questions?
We do have a couple. Thank you both so much. That was just really brilliant and inspiring. And it was great to see that I think even in your presentations, you took quite a strength-based approach to talking about the places you visited. Jen, you did get a question. Did you answer it yet? Sorry, it says you're typing an answer, but I'm not sure if you did. But
yes, I'm happy to just say my answer.
Yes,
so
well, I'll just read it
Lindsay,
out quickly, and this is something I'm sure we all heard, but Lindsay from Legal Aid New South Wales asked, did you discover any tools or approaches during your interviews to help solicitors manage dealing with their own trauma response triggers when helping vulnerable clients? So thanks, Jen.
So I think this is a fantastic question. And I guess I'll say that, like, if we zoom out a little bit, I think that when it comes to managing vicarious trauma risk, there's a strong organizational obligation following the High Court decision of Kasparov, in relation to our safe work obligations and just work health and safety legislation in general, to make sure appropriate protections are in place in job roles with an inherent vicarious trauma risk. But having said that, I also think that, and I think that's really important, because often when we talk about vicarious trauma, there's sort of disproportionate sort of responsibility assigned to the individual. Like, on top of your busy workload, you are also responsible for your own well-being. So I think that big picture piece needs to be said in response to what we can do. But I guess when you talk about your own, like, people, lawyers' own trauma response triggers in your question, I think that's very personal. So I think your question reflects self-awareness, and it's based on an assumption that lawyers are aware of how their own personal experiences might impact their work, especially, for example, in situations where you might have a client who's the same age or who presents in a certain way to yourself or to someone close to you, and that might be really challenging, for example. So I think the response is really most effective if it's personalized. And I think lawyers can seek help from people they trust, including mental health professionals, to develop those really personalized plans. I'm really sort of hesitant to give any generic advice, because there's such a broad range of people's experiences and triggers and the way that people might be triggered through their work. I did read a lot about grounding strategies, for example. So if you're, in the moment, if you are in back-to-back appointments and something's really challenging, but you have a client waiting outside the room, like, maybe having some grounding strategies that work for you up the sleeve could be helpful. But in terms of exact things that you can do before or after work, or in terms of changes to your job design, if that's possible, in terms of being able to express to your manager whether or not there are certain matters that you prefer not to take. We hear about lawyers, for example, working in child-related areas who, have arrangements where they don't take on matters with kids of the same age as their own children, that kind of thing. Like, that personalized approach really needs to be tailored to the particular lawyer's situation in discussion with their manager and the supports in their personal life. I hope that's helpful.
Thanks, Jen. And then there was a question also for Elicia, which is, did you observe actually any child protection hearings and notice any difference in outcomes or processes overseas?
Yeah, so I was able to observe hearings in the US. I wasn't able to observe the direct hearings in Scotland and Northern Ireland, but I did get to watch a mock hearing in Scotland. So what was the key differences, I think, in the US were that children were welcome in the court. So children were able to come. They had a lot of the courts had things set up so children felt welcome. They had books. A lot of judges would give children something to say thank you for coming, so they give them a book or a toy. In Philadelphia, there was one judge who had her whole courtroom set up with Barbie dolls, which was really amazing to look at. Another case, I saw a child come to court with their mum. The child was 3 years old, so not participating in the case themselves, but the court welcomed the child, had bought some special treats, some donuts and things like that for the kids. So court was seen as a positive, not traumatic environment. Kids weren't, I think that went a long way for kids not being worried about their parents going to court as well. And if those kids are going to go to court later as they get older as well, I think it was just a really positive, it set up a much more positive environment for them. There was a real recognition of the use of remote and hybrid hearings as well. So, that's, something to take with caution, because that actually does facilitate a lot more participation. We're not taking kids out of school if that's how they want to attend. But, just, I guess, a caution with that is we've still got to have genuine participation and allow them there. They're not just distant on the screen. What I did love about Philadelphia was that there's a requirement for children to be cited by a judge. So, you know, that might sound tokenistic, but there actually was some recognition that this child is not a name on a piece of paper. Like, we actually need to put a face to this child and see them. And there's a requirement for evidence to be given by the child protection worker at each hearing to give an update about the child. So I think it was just a little bit more, just some of those structures about putting the child at the centre was really important. I think one thing I found amazing in New York, I did see amazing lawyer ask the judge to ask the child protection worker to stop referring to the mother as the mother and refer to her by her name. And the judge was beautiful. She dealt with it so well, and everyone just stopped, checked themselves, and it was really great, sort of humanizing that for the family involved.
Thanks, Elicia. Just those small actions can make a big difference. A bit like what Jen said at the end of hers. Start with the person in front of you. Elicia Buchanan's asked a question. Just quickly, the physical space that you put up for the CP proceedings in Scotland is amazing. I agree. Do we know of any similar examples in Australia? And we only have about a minute left, so.
Sure. Well, I would say have a look at Marinella Gumbu, so the Koori Family Division Court in Victoria. There might be other ones across Australia, but I think that's a really great example of how all children's courts should be run. So yeah, we've got some of those sort of problem-solving courts, Marinella Gumbu, Family Drug Treatment Court, which Jen's referred to in her thing as well, in Victoria, and I think they're great practices we should roll out more widely.
Yep, agree. Thanks everyone so much for joining us. We will send the slides out. Someone asked that, and the webinar recording. Please share it with others in your organisation, and let's keep this conversation going. It was great to hear from both of you, Elicia and Jen. Thank you so much.